What does the FMLA require before and during the employee's FMLA leave? An employer who's covered under the FMLA is obligated to provide employees with certain critical notices about the FMLA. General notice. All covered employers must display a general notice about the FMLA, sometimes called the FMLA poster. If a covered employer has any eligible employees, the employer must also provide each employee individually with a general notice containing information about the FMLA as contained in the FMLA poster. Eligibility notice. When an employee first takes leave for a reason that may qualify for FMLA leave, the employer must notify the employee whether he or she is eligible for FMLA leave. Rights and responsibilities notice. If the employee is eligible, the employer must notify the employee in writing about employee rights and responsibilities under the FMLA. Designation notice. Once the employer has enough information to know whether a leave request qualifies as FMLA leave, the employer must notify the employee in writing whether the employee's leave will be designated FMLA leave and the amount of time that will count against the employee's FMLA entitlement. To take FMLA leave, employees also must provide their employers with appropriate notice. Employees should follow the employer's usual and customary workplace procedures for requesting leave unless they are unable to because of unusual circumstances. In general, when an employee knows about the need for the leave in advance, he or she must give at least 30 days advance notice if it is possible and practical to do so. If 30 days advance notice is not possible because the situation has changed, or the employee does not know exactly when leave will be required, the employee must provide notice of the need for leave as soon as possible and practical. Eligible employees may use up to 12 work weeks of FMLA leave in a 12-month period and up to 26 work weeks of leave during a single 12-month period for military caregiver leave. Employees may take FMLA leave all at once or, when medically necessary, in separate blocks of time or by reducing the time they work each day or each week. Intermittent or reduced schedule leave is also available for military family leave reasons. Employees may use FMLA leave intermittently or on a reduced leave schedule for bonding with a newborn or newly placed child only if they and their employer agree. If an employee has health insurance through an employer's group health plan, they can continue their group health insurance coverage during FMLA leave on the same terms as if they had continued to work. For example, meet Carla. Carla takes FMLA leave to recover from surgery. Her employer continues paying their share of her health insurance, and Carla is responsible for paying her share to maintain coverage. Returning to work. Upon returning from FMLA leave, the employee must be restored to the same or an equivalent position with equivalent pay, benefits, and working conditions. Employers cannot retaliate against employees for taking FMLA leave. For example, when Carla returns from FMLA leave, her employer must either reinstate her to her original position or a similar one with the same pay and benefits. Other benefits: the FMLA requires that benefits such as life insurance, disability insurance, sick leave, vacation, educational benefits, pensions, retirement or 401k benefits, etc., must also be available when the employee returns from FMLA leave. These benefits must be resumed in the same manner and at the same level as when the leave began, unless changes came about that affected the entire workforce. An employee returning from FMLA leave does not have to requalify for any benefits he or she had before the leave began. Questions about FMLA rights and responsibilities during leave? Visit dol.gov/WHD or call us at 866-487-9243. We're here to help.